Hello everybody, it's Walter, your favorite historian and educator, here today to teach you about congressional authority over the Supreme Court's appellate jurisdiction. A lot of people today complain about how the Supreme Court has taken a rogue and renegade path, overturning long-standing precedents, making decisions that run contrary to the Constitution, and simply doing its own thing in the face of both law and history. Well, one thing that a lot of Americans don't realize is that the Supreme Court is not entirely final and absolute in its decision-making at all times. As a matter of fact, the framers of our Constitution provided many mechanisms for controlling the power of the Supreme Court. One of those mechanisms is known as jurisdiction stripping. You ever heard that term before? Well, jurisdiction stripping is a power vested in most legislative bodies that allows them to remove jurisdiction from courts of law or courts of equity, depending on the circumstance. All right? Now, and when I say legislative bodies, I am referring usually to state legislatures and, of course, the United States Congress. In this case, we are referring to congressional authority to strip the Supreme Court of its ability to hear certain types of legal issues. To find this, we go back to our trusty source for all things constitutional, the United States Constitution. We go to Article 3, Section 2, Clause 2 of the United States Constitution. Article 3, Section 2, Clause 2, which reads, "In all cases affecting ambassadors, other public ministers and consuls, and those in which a state shall be a party, the Supreme Court shall have original jurisdiction. In all the other cases before mentioned," those cases in Article 3, Section 2, Clause 1, all right, "the Supreme Court shall have appellate jurisdiction," all right, "both as to law and fact, with such exceptions, and under such regulations as the Congress shall make." Pretty straightforward, right? So what that section is saying at the very end is that Congress has the authority to take away the Supreme Court's ability to hear certain types of legal issues, whatever types of legal issues that Congress desires, as long as it is not something that falls under the court's original jurisdiction, which is set in the Constitution. Okay? Now, the original jurisdiction, just to be clear, covers this. In all cases affecting ambassadors, other public ministers and consuls, and those in which a state shall be a party, the Supreme Court shall have original jurisdiction. That's the court's original jurisdiction, and it is set in the Constitution. It cannot be modified by acts of Congress in any way, shape, or form, or anything else. We learned this from the landmark case of Marbury versus Madison. I'm sure you probably learned about that case, or at least heard of it, in social studies class or just government, all right? Doesn't matter. I know you've heard of Marbury versus Madison, and that's what that case was all about, all right? It's the first time the Supreme Court ever held an act of Congress, or a part of an act of Congress, to be unconstitutional, all right? Because it effectively enhanced, what was at issue in the case was a law that effectively enhanced the power of the Supreme Court's original jurisdiction when that is clearly set in the Constitution, all right? So that was a no-go, all right? Anyway, back to the subject at hand. Everything else, all right, falls under the court's appellate jurisdiction. In other words, it has to go through another court first before the Supreme Court can hear it, all right? Original jurisdiction means it can go right to the Supreme Court, all right? File the case right there at the Supreme Court to start it out. Appellate jurisdiction means it has to go through at least one other court first before it gets to the Supreme Court, all right? So if it doesn't fall under what I just read, in all cases affecting ambassadors, other public ministers and consuls, and those in which a state shall be a party, the Supreme Court shall have original jurisdiction. Those are the only types of cases which the court has original jurisdiction. Everything else Everything else, the court has appellate jurisdiction to hear it only. All right, so it has to go through at least one other judicial body first. And in anything else but those matters that I just said, the court's appellate jurisdiction can be regulated by Congress, and Congress has the power to strip the court from hearing certain types of legal issues. All right, ladies and gentlemen, the matter was affirmatively decided in the case of Ex parte McCardle in 1869, when Congress, pulled from the court the authority to hear certain types of Reconstruction appeals. All right, so Congress could protect the Reconstruction laws from judicial review. The court affirmatively decided that Congress, under the Constitution, has this power, and there's really nothing the court can do about it. Of course, the court wisely reasoned that does not apply to matters that have already been decided. But even if a case is pending before the court and Congress pulls jurisdiction from the court to hear the case, the court has no choice but to dismiss it. So the point of it all is that Congress has the absolute unquestionable right to pull from the Supreme Court the ability to hear certain types of legal issues. If Congress wanted to take away the Supreme Court's right to hear abortion cases, it has the right to do that. All right, and there's nothing the Supreme Court can do about that. Congress has the power under the Constitution to pull from the Supreme Court the ability to hear certain types of cases, any types of cases that fall under its appellate jurisdiction. If Congress wanted to take away the court's right to hear bankruptcy appeals, so be it. That's Congress's right to do it. All right. If Congress wanted to take away the court's right to hear cases that arise under virtually any minuscule federal law, rather any federal law, minor or major, as long as it doesn't have anything to do with the court's original jurisdiction, Congress has the right to do it. And that is one of the mechanisms the framers of the Constitution provided to check the power of the Supreme Court. All right? Congress has the power to check the Supreme Court by taking away its ability to hear certain cases under its appellate jurisdiction. Now, whether or not Congress will ever have the stones to do that in the modern era is a different subject for a different day. So that, ladies and gentlemen, is how Congress may check the power of what is perceived to be an out-of-control activist Supreme Court. So I thank you so much for listening. If you have any questions or controversies, you can leave them down below, and I'll be happy to answer them. Hopefully you learned something from this video. Got a thing or two from it. Don't forget, read your Constitution. Take care. Stay safe out there. I'll talk to you at the next video. And in the words of my teaching role model, Mr. George Feeney, believe in yourself, dream, try, and do good. Peace out.